Now we're live, sir.
The time is now 10:48 p.m. and the executive session has been concluded. The participants in the executive session were Mayor Mark Browning, Mayor Pro Tem Jim Wingard, Trustee Julie Jacobs, Trustee Amy Schwartz, Trustee Greg Lowell, Trustee Lee Williams, Trustee Mariah McCreary, Attorney Brandon Dentman, Administrator Victoria Simonson, Town Clerk Dolores Vasquez, and Town Planner Lisa Ritchie, and Town Utilities Director Aaron Packman. For the record, if any person who participated in the executive session believes that any substantial discussion of any matters not included in the motion to go into executive session occurred during the executive session, or that any improper action occurred during the executive session in violation of the open meetings law, I ask that you state your concerns for the record. Hearing none, we will proceed. And the next item on the agenda is the second reading and public hearing of ordinance 1219. An ordinance approving the quitclaim deed from the town of Lyons to Ken and Lana Cinnamon for a portion of property located at 0 Stickney Street. Does the town attorney want to kick this off, or does he want to?
Yeah.
Okay.
I'll kick this off with kind of a brief introduction, both to remind the board and also kind of inform the public, since there are a number of interested individuals here today. So as you're aware, the town has been in discussions with the Cinnamons for some time to resolve a dispute concerning 0 Stickney Avenue and maintaining access for them, for the social trail that exists there, for the town's right of way and utilities, and trying to find a solution to that complicated problem with a complicated history, to say the least. Procedurally, Colorado law requires us to do this via transfer property via ordinance. And so that's why it's an ordinance that's before you today. This is just one step of a multi-stage process if it were to move forward. This is, we already passed a resolution declaring the property surplus, that this small portion of the property is no longer needed for the town, minus the utility easements that would be reserving. That's kind of step one. Step two is to transfer the property via an ordinance, which is what this is. There's also a settlement agreement that would happen after this that kind of lays out the additional steps, which would be vacation of the right of way, and also a replatting of the property. And just kind of given the nature of this process, these are not happening, all at the same time necessarily, but in close succession, as is technically possible, kind of given the complication of what we have on our hands. That's the legal process. Tonight, the board would be considering as part of this whether to move forward with transferring this quitclaim deed for this portion of the property. I think we're pretty aware of all the relevant issues here, but I'm happy to answer any questions that the board has.
The next step is, does the board have any questions of the town attorney or the town staff regarding this? So was it part of your questions? Okay. So I believe that the next step at this point is to open the public hearing for discussion of this. I will now declare the public hearing open, and I would remind the people that are here that your emails, you should presume that they have been read by the board. But if you wish to amplify on those or make further comments, you are obviously free to do so. So I will open the public hearing at this time, and procedurally, I believe we generally enforce our 4 and 3 minute limits during public hearings. Brandon, is that correct?
Yeah, the board has discretion on what the time limits it wants to set, but I think traditionally it's 4 minutes.
Okay. Entertain comments from the public for 4 minutes. The board does have the discretion, as indicated, to extend those if need be. And also procedurally, is the board free to ask questions of people who present comments at the public hearing?
Yeah, I think, clarifying questions can be asked. I mean, I maybe would suggest, kind of given that there are questions to be asked, we suspend the rule concerning the time limits, kind of to facilitate that. That way everyone had equal opportunity to get on the record what they would like.
Okay. So if we ask questions, that's not really counting against their 4 minutes.
And I'm suggesting maybe we suspend the time limit altogether, just so people have an equal opportunity.
Okay.
It's to the board's liking. That way, no one can, speak more than another person, within reason. If someone, or if we want to extend it out to, accommodate, we can. Um,
Fine. Fine.
Is the board okay with that?
No.
Let's set the ground rule before we start.
yeah, Victoria, would you like it, 5 minutes, 6 minutes? I'm just trying to, if we're going to ask questions, everyone needs to have an equal opportunity to speak. So that's what I'm trying to accommodate for.
I guess I would let everyone have their 4 minutes, and then if there are questions, you let that person come back up and answer them.
Or,
Okay.
or if you need your 4 minutes, if
Yes,
the board asks questions,
then
then,
that's fine.
then the time.
Continue to interact.
Yeah,
You
I
know
just want to
what?
make sure everyone's on the same level playing field is what I'm trying to set here. So.
Okay, do we have a sign up order here? We're just gonna take.
No, this is the only public hearing, so.
Public hearing, so anybody wishes to speak, you're welcome to.
I just have a question.
Okay.
I'm here on behalf of, the Cinnamons, and, I had a different understanding as to what was going to occur here this evening, so I just wanna.
Sure.
Cause I understood that we kind of had unlimited time, not that I intended to
No,
take a
but the
lot of time.
applicant could present.
Correct, and so when
Yeah.
in this process would that occur?
And this is not a land use application, so it doesn't have the same, kind of procedural due process, as considerations. How long do you think you need to speak? I guess would be the question.
Oh, somewhere around 5 minutes, maybe a little more, maybe a little less, but I just didn't know where within the.
I think,
Speaking tonight where we would fit, if we could be at the end, that would be great to me, but if you want to do here at first.
I think it might be helpful if you laid out the Cinnamons position, because that's the party that we've been principally negotiating with all along. I think it would be helpful if you would go first, and
Okay,
we will be flexible on the time limits, and we could always ask you a question and extend it if we need to.
okay, thank you very much. My name is Robin Cubey, and I'm here on behalf of Lana and Ken Cinnamon in connection with this matter, which, as you folks all know, is settling a land use dispute. And so, like many other property disputes and land disputes in Boulder County, this one involves historic documents, some dating back to the 1800s, and then conduct by landowners and the neighbors that are perhaps inconsistent with what those documents might say. And I think, as you've probably been advised by Mr. Dittman, this is a messy fat case again, which is pretty typical for these sorts of things. We're here because after because the town chose to take title to some property adjacent to the Cinnamon property on at Stickney and Seward, and as part of that, the Margaret Russell and her husband had acquired a tract of land from the Small Business Administration back in 1974. They bought it, they pay taxes to the town, well, they pay taxes to the county, which then the town benefited from. And then they decided, when both of the Russells died, the estate of Margaret Russell chose to give the property or convey the property to the town. The Cinnamons had a long history with the property on Seward Street. Well before the time they bought it in 1987. Mr. Cinnamon's grandparents had previously lived there, and he'd spent a fair amount of time there when he was younger and was very familiar with the property. When they bought it in 1987, they understood that the driveway was on their property and that they owned some portion of the property east of the driveway, but weren't really sure exactly where that was, where that eastern boundary was. After they bought it, they used the entirety of their front yard, the driveway, and the area to the east of the driveway as if it was their own. When the Russell conveyance came up in 2025, Mrs. Cinnamon objected to the town accepting title for a variety of reasons. Part of it was their historic use of the driveway in the area to the east, and what did this acquisition mean for them? She's also concerned about the possibility that the town might expand the social trail that's located just to the east. In any event, the town chose to accept title, early last year. And as part of those discussions, they recognized that there were some issues with people who had been using, the land, that was gonna be donated. Last summer, the Cinnamons formally notified the town that they claimed adverse possession to the property where the driveway was located, and they sought to negotiate a resolution with the board. I see you folks are all kind of looking towards the demonstrative I have here, which is an enlargement of the amendment to the plat of Nortonville, which is the document that would be executed assuming this conveyance is approved. And I wanted to point out some things that have caused some questions for some people. The property that would be conveyed is highlighted here.
You're welcome to come forward.
Is highlighted here in yellow. And the Nortonville subdivision is here bounded by the red, with the Cinnamon properties being lot 7 and lot 8. The property that the town acquired from the Russells is the property outlined in purple. And then the green property, or the property with the green boundary, is the Mountain View subdivision. And that's important because something I'll mention in a minute. When after the Cinnamons raised their claim, the town, acting through Mr. Dittman, acknowledged there were many messy facts related to the dispute, and that the town would be willing to grant an easement to the Cinnamons to resolve the dispute. And much of the negotiation since that time has been in connection with what property exactly the Cinnamons might receive from this settlement. After we began talking, the town took the position for the first time with the Cinnamons that a plat of Nortonville dating from 1886 would be interpreted as creating an 80-foot right-of-way, public right-of-way to the east of the platted lots in Nortonville. So going back to this amendment, that's the area here to the east of the red line. And that 80 feet, frankly, would extend 20 feet into what's now the subdivision for Mountain View, because the distance between the two boundaries is only 60 feet. So if you consider the width of that right of way to be 80 feet, the town previously allowed that to be incorporated into the Mountain View subdivision. In any event, despite the town raising that for the first time, the town nevertheless offered 2 resolutions to the Cinnamon, and one was an easement and the other was fee title. And so the Cinnamons chose the fee title approach to this, and the documents that you've seen, the settlement agreement and the other documents, all are tied to them acquiring title to the property, generally what's highlighted in yellow on this amended plat.
Did I ask a question there about the yellow?
Sure.
We've seen differing proposals from the Cinnamons. The yellow property there extends basically to the streetway and basically parallel to the fence line that the Cinnamons have that runs east-west. But a recent proposal from the Cinnamons seemed to reflect that the southern extension of that property would extend out into what's basically considered the street. So we've been unclear as to what the Cinnamons' current position is as to how far south that yellow property area would extend.
So the main part of the yellow property, the southern boundary of that has never changed from our side. The southern boundary has always been discussed as being a continuation of their southern property line of lots 7 and 8. What has been in contention or has been discussed is what's been referred to as the bump out. So that's this area in the north part that sticks out a little bit further to the east.
To clarify, do the settlements contend that their property line extends out into the pavement of the street? Is that?
Yeah.
It's hard to tell from this.
Looks like it.
but
That's what the survey reflects.
Yeah, so this is, this is what the survey shows, excuse me, the work performed by the surveyor is exhibited on this board in front of you. Reflects that their southern property line for the lots they clearly own, 7 and 8. Extend into the existing pavement for what was originally considered identified as an alley on the old Nortonville plat. And so this goes back to my earlier comments where you have documents that reflect certain things, but what's happened physically on the ground is inconsistent with that. And that's one of the indicators. So this is just, so the southern line of the entire parcel to be vacated and conveyed extends their property line to the east. There's been talk about how wide this bump out should be, which is this area which is extends east from their garage. And there's evidence that they have used this property east of their garage, east of their driveway. And that line is again parallel to another fence line on their property, or an extension of that. So that's where it's this area here, near the northeast corner that's been somewhat involved in discussions with you folks.
Another question, the red line on your map there is where they would like to build a fence, is that correct?
No.
No.
No, the
No.
purple, no, the fence would be on the east line of the property being conveyed to them. This is their main property, what they clearly own. I have smaller versions, bigger than what you probably may have seen otherwise, but smaller versions of this that I can pass out to each one of you. But their fence line is depicted on here. As it exists today. And then you pick up this shaded area here is where the paved driveway is.
And would they be proposing to extend the fence on the east side of that yellow portion any further than their existing fence line to the south? Their existing fence line, I guess it's maybe not right at the property line.
They have no fence at all. Well,
Right,
on the east side of this, there's no fence
right. So I
currently.
guess my question is, how far south are they requesting that they be allowed to extend their fence?
All the way down to the southern end of the property. And based on feedback that we've previously gotten from the town, it's roughly 3 feet out from their driveway. The driveway's not a straight line, so it's a straight line where the narrowest part is 3 feet to allow for maintenance. And the fence would have to be somewhere inside there. I mean, on their property, so west of the east line.
Questions from other board members?
Yeah, I want to make sure we all are on this. Everybody's talking about this thing.
Are the sentiments satisfied with the north-south dimension of that bump out?
Can I
Yes.
answer that? Would you want me to answer that?
Sure.
Yes, yes, we are. We don't intend to. We're just gonna make it straight with our property line where it is right now. And our driveway, and take 3 feet from where our asphalt is over so we can put a fence in and mow it, which we always have done. And that's on the north-south. Now, the north on that does not it does extend our property line to the north. doesn't
So
it?
you need to come to the podium and identify yourself if it's gonna go.
Don't walk very fast.
Yeah. So we have to record minutes and we have to identify everyone that's on it, and so that's one reason I'm asking.
I'm Lon Cinnamon and I live at 208 Seward Street here in Lyons. I can tell them on it, what my understanding, yes. Lord knows that may not be right. Where's your big? Okay. This, and correct me if I'm wrong, so come over here. This is our property line right here, as far as I know. Right here, and then our fence line curves around here. But we're extending, all we want to do is square it off, rather than have all these things on the survey. We just stay with the same line we've got right now, right straight across. Then this is the 3 feet right here, so we maintain it, and this is the bump out. There's been a lot of discussion about this 5-foot bump out. And there's several reasons it's important to us. This is our fence up here by the house. We want to make it parallel. I guess it's this to the same as that fence, so they're even. But this property we use to park and to back out with, that's true. But we also use it for parking. We have no on-street parking. We live on a 10-foot alley. We can't park cars there. So if we have guests, they park in this bump out area. And we also use it to, when we're backing out, it's more convenient for us to do that.
Thank you.
No, it's fine.
I guess another question I'd like to get kind of on the record, the fence that Ms. Senator was just talking about.
Can I approach you folks and I can give you a smaller version that maybe I'll make things a little clearer for you?
Would the Cinnamon view the fence that they would like to construct on the east side of the property, including the 3 feet that we've been talking about? Do they do that as interfering in any way with access to the social trail that's listed there for me?
No, and in large part, that's because if you look on the map there, in the area between the purple and green lines, down there, you can see that the surveyor had depicted the social trails that exist. And so you can see that there's a trail coming off there right at the southern end of this parcel that then connects into the trail that comes on up to the north and connects to the trail as it heads northeast up the hill. So there would still be access to the existing social trail. And that trail is roughly 10 feet east of the property that would be vacated to them. And there's, like I said, there's still this available access. I mean, the biggest change, I'll be honest, to the public is they won't be able to walk down the Cinnamon driveway anymore like they currently do.
Thank you for these small maps. They are more visible than that. Could you explain why Cinnamon believed that they would need to extend the southern boundary of this yellow area basically into the pavement? Now, use-wise, as long as they are able to access their driveway from the public streets, why would they need to extend this past basically the existing east-west fence line?
We don't want to extend it past that.
Yeah.
In other words, if the southern boundary of this yellow area were moved, I'll guess at the footage, but basically past where the curve is, at the end of, I guess that's
Well, that's the way we paved it.
Why do you need that basically southern 10 to 15 feet of that yellow area?
You know, I'm not quite sure I'm understanding this. Let Arnie talk.
I think.
So one at
let's-
a time, please. We have to get it for the record. So please, if you only respond once recognized.
Yeah. So
Honestly,
my question is, this is a concern to the board of why that yellow area needs to extend out into the pavement, however many feet it does.
I don't think that doesn't extend out the pavement. I don't understand you.
Here, so.
Right on our property line.
But on there, what's mapped out goes to here, so that's showing the fence come down to here.
Oh,
where
no,
your
no, no.
Fence only comes to here now.
Yes, and that's where it will come to that.
So this is Robin QB again, so I'll explain. We have not. This is the first time that I have understood there be questions about how far the parcel itself was extending to the south. And so it had just been drawn this way to reflect the surveyor's extension of the existing property line. To the extent the board thinks that that's going too far south, and maybe they would be more comfortable with it tracking this. Some other part of their east-west fence line, so it was symmetrical or whatever. That's not come up before, it's not to say that it wouldn't be considered.
That has been a big concern to the board.
You know, and I.
Is a big concern.
Excuse me, the prior board raised different concerns than you're raising, so that's part of.
All right, any further questions, or we should hear from other people? This point. Thank you for your presentation.
Jim Fairmount View Drive, just wanna. First off, you have my write-up, I think it's very clear, I don't think there's an adverse possession case here in this case, because they just admitted that people walk down the middle of the road. I go up, access my yard with a vehicle, I've had trucks back there, I've had trailers back there. So I'm concerned that this fence will block me off. I guess I'm gonna stop there because you already read everything I had to say. And the one thing I do wanna say is, thank you for moving this up. It's already it's 11 o'clock, but at least it's not midnight. And it is a public hearing. And I want to also recognize the Redstone Museum. I found a whole bunch of information there. And I could go on and on, I could talk for another half hour on this property. But I'm not going to.
Yeah.
That's it, true.
What?
Show me where the gap is.
Oh, Kate wants me to show you the gap. In my mind, it's just not ready for prime time. Here we're on the second reading. And you got this gap here. And it's between the Mountain View subdivision and what is it? The Nortonville. So, it's like, wait, we got more issues here that need to even be addressed if we want to keep going on this thing. And so I encourage you to, because of all these issues, just to stop to it now and, not take hours and hours of the extra time. Yes.
Jim, let me ask you another question. If that yellow area were shortened by, say, I don't know what the estimate there is, 15 feet, 20 feet, would that allow access in your backyard?
I think,
Right about where it says Town of Lyons on that map, that little section on the bottom, if it were, if that was shortened and that part was taken out, is that typically where you access your property?
well, we access our property up here. This is our,
Yeah, okay.
this is our property, this is the outlot that I mentioned in the thing that got added in 1994. When, the town, it got deeded to, the town alliance to keep that public right of way open. And so, we access through this outlot A, coming up the driveway and coming over. And again, I consider it a public right of way, not some, you know, again, adverse possession, you have to have exclusive use. They do not have exclusive use, so they can't, they couldn't win an adverse possession case. The only place they could potentially win an adverse possession case is on this fence. This one little section here, but not on the rest of it. And then if they won that, they'd have to pay, property taxes for 18 years plus the value of the property. And right now, you're just giving away land, so, and plus, if you negotiate with them, I got other cases, I've looked at, it can cost hundreds of thousands of dollars to negotiate, to run these things through the courts. And so they're not gonna wanna do that. So the chances of them going and suing the town are fairly remote in my mind. Maybe they'll just do it anyways, but I don't think the town's in that big of a legal bind at this point in time.
One more follow-up. Has there ever been any objection to having your contractors or yourself driving up that driveway to access your backyard?
No,
They've never done it, ever. Right up our driveway.
Let's
every year.
wait, let's. Mr. Kerr has the floor, so no audience comments while he has the floor, please. Have you ever, in the past, when the Russells held title or claimed title to this property, or with the Simmons ever discussed with either of those parties some type of access agreement to your property, easement, anything? Has there been a discussion of some formalizing that relationship?
early on, when I first moved in there, they mentioned that they didn't have any problem with me accessing my property.
They being the
The
Simmons?
Cinnamons, yes.
There was never any discussion with the Russell heirs or?
No, I never talked to the Russells, At the time when we first moved in there, they were in tax, I think delinquency, and subsequently it got made up. So I don't have all the details on that, but it's my understanding that the taxes were made up by the Russells.
Further questions of Mr. Kerr?
Thank you.
No, the next speaker.
Evening, Mayor and Trustees. It is sure nice to see you from this side of the dais. I wish I didn't feel the need to be here at 11:30 at night. I support Mr. Kerr's suggestions in his emails and his remarks just now. In my opinion, the board should not give town-owned land to a private citizen for the enrichment of that citizen and that citizen alone in the form of significantly increased property value. I understand the motivation of wanting to avoid the cost and time a lawsuit might entail. However, to me, that is certainly not reason to capitulate to the Cinnamons' demands. I will add that if this ordinance does pass a second reading, it sets a precedent. And I will personally be the first in what will probably be a very long line of citizens asking for the same thing. And every citizen that I've spoken to about this will support a referendum to overturn passage on Senate. Finally, I do not think having a public hearing on a second reading regarding a matter that includes giving away town-owned land to benefit an individual after 11 p.m. lends itself to either accessibility or transparency. The attorney for the Cinnamons was just provided apparently unlimited time to speak, and in fact was able to give an entire presentation that was not noticed on an agenda, not simply testimony, which is absolutely unacceptable. It veered very close to negotiations. I am sure the public would have appreciated being able to hear the conversations, but they were not noticed on an agenda. I thank you very much for your service, for your time, and I know it's a very late night, so I'm going to stop.
I don't think you stated your name.
Oh, sorry, Holly Rogan on CBC.
My name is Ken Cinnamon. I live at 208 Sawyer Street. we've owned our property for 40 years. And probably nobody in this room can say that they've lived in the same residence for 40 years. And during that time, I think we have one of the nicest properties in Lyons. We worked very hard to keep it nice. When we first moved there, we had a gravel driveway, which we had more gravel hauled in. Eventually, we paved the driveway, which we had a receipt for, by the way. We've always been generous with our neighbors. I don't know why Mr. Kerr all of a sudden is feeling that we are trying to take away his right to his property, but we're not trying to do that. We just want to have ownership of our driveway and a little bit of space beyond less about that. That's all we want. We're not asking for anything else. I have to also say that we have put up with a lot not fun things in our driveway because lots of people like to bring their dog to the top of the driveway and unleash it and let it run up into the Russell subdivision. We've had our cats beat up. We've had dogs come inside our garage and pee inside the garage, dogs in our yard. We're just sort of tired of all that. The bottom line is we have taken care of that driveway and that property for the last 40 years. And we think that we deserve ownership of that. That's all we're asking, no more. We're not trying to make any money. We're not, Mr. Kerr inferred in his letter that we were wanting to become land developers. My wife and I are both 76 years old. We haven't divided those lots up in the last 40 years. Plus I own another house that has 2 lots and I've never divided those lots up. We're not trying to make money off of this. We just want to secure our property. And then Miss Roggins, or whatever her name is, also suggested that we were stealing water from the town of Lyons in the letter. If you look at her letter, she infers that. We have never stolen any water from the town of Lyons. She probably needs to learn about slander and libel if she's going to continue talking about us. And then the last positive thing is, by the way, I'm a 40-year member of the Lions Club. Thank you.
Mr. Cinnamon, any questions of Mr. Cinnamon? I have a question.
Okay.
If it was necessary to resolve the multi-party dispute that we have here, and save everybody, including town taxpayers, you, surrounding property owners, a lot of legal fees and legal risk, would you be willing, would you and Lana be willing to consider granting some type of access to the Kerrs to the property for a limited purpose?
Not vehicular, and to my knowledge, there's never been vehicular access.
But let's confine the discussion, if we could, to those about voting. If you build a fence there, as you've intended to do on the east portion of this property, that only the Kerrs will block access to their property, would you be willing to consider any type of a gate? Kerrs pay for the gate. We discussed that later. Gate access with some type of a limited agreement for them to be able to access their property, as they say they have historically done.
I probably would not have a problem with that. But I am going to say historically, if you come up and look at the property, there are no tire tracks going up to his house from our area. So I don't think he's ever driven up there. I don't know that for sure. Not why I'm there, but yeah, I would consider that.
Thank you.
Yeah, I mean, put a gate in it, but I don't want that gate to be opened by pedestrians coming up our driveway all the time.
Understood.
Okay, so otherwise, that's probably not a problem.
Thank you. Anyone else who wishes to speak on this?
I'm still Dave Chilson, 751 Second Avenue. And I'm talking about Second Avenue and Stickney because my property borders both of them. And I have a thing that's coming up before you guys, I think in July, probably, which is similar, and I don't want to talk about that, but I would say that I have a unique perspective. First of all, I agree with, Mr. Cinnamon that the public goes up his driveway. I go up his driveway very often because we use the social trail, and my concern is for the social trail that we continue, that the public still has access to that. And that no matter what the intentions of the Cinnamons are now, future property owners or changed minds don't close it off in some way. And, when we first moved to our house, our next door neighbors sued us for adverse possession. They used the former town attorney and another attorney, and some people here remember it. And we represented ourselves, and it was very clear to me that they didn't have all 5 elements of adverse possession. We warned them, they spent well over $100,000 and we won. And then they took it to the appellate court, hired 3 more attorneys. And again, representing ourselves pro se, we won. So I can tell you from my perspective, there is no exclusive ownership of that property by the Cinnamons. That's my opinion. There has to be 5 elements. You could argue back and forth on 4 of them, but on the 5th one, it can't happen. There's no sign, there's no gate, there's no hedge. There's no fence. And as Mr. Cinnamon said, people walk up his driveway all the time. So that doesn't mean that people don't get into lawsuits. People can sue anybody for any reason. But getting thoughtful legal advice from multiple people, I think, the Cinnamons probably would not win that case. And in my case, because the next door neighbor sued us and very clearly didn't have those elements of adverse possession, we were awarded our entire costs. So every time I drove down Second Avenue to mail something at the post office, I counted that. we got $7,000 back just for driving around. So those are my 2 cents. They're kind of multi-pronged, there's a lot there, but that's my opinion. My main concern is about the social trail.
Thank you.
Yep.
Anyone further wish to speak? Hearing none, close the public hearing. Yes, the next step is now, board discussion of this ordinance.
And probably a motion a second to open up the discussion on the ordinance.
We have a minute to open up discussion.
Well, to pass the ordinance or to vote down the ordinance, to have discussion afterwards.
For purposes of discussion, would anyone like to make a motion regarding ordinance 1219? Let me ask the attorney, is it possible to make a motion to reject ordinance 1219 and then
Yep.
discuss?
You can.
Anybody like to make a motion?
Yes, I move to reject ordinance 1219, an ordinance of the town of Lyons, Colorado, approving the quitclaim deed from the town of Lyons and in Lyons and for a portion of property located at 0 Stickney Street.
There's second.
I'll second.
Motion been made and seconded to reject ordinance 1219. Now we will open this up for more discussion. Anybody who will volunteer to go first on this?
I'm happy to go. This isn't ready to move forward for me. I too share concerns around the social trail. I just have a wondering if can we do better in mediation or, I think there's a willingness to accept alternative proposals and, I think we can do better than the proposal presented today.
I guess I'll go second. I would like to make a few points that I think are not clearly understood by some. The proposed settlement, as we, the board, have understood it, would not impede access to the social trail. One of the concerns that I discussed earlier with the Cinnamons lawyer about what we viewed as a southern extension of the territory that they would like conveyed to them, one of our concerns was, would a fence along that property block the social trail, whereas a more northern location of that line clearly would not block the social trail. So the idea that this settlement precludes access to the social trail, in my view, is correct. In fact, we specifically in a public session after an executive session said we were not going to accept a southern extension of their property into the pavement of the street because we were concerned about it blocking social trail access. So I think the contention that several people in their emails have suggested that this settlement will prevent public access to the social trail is incorrect. I'd also like to explain briefly to the lateness of the hour that day one is when the prior board considered initially taking a quick claim deed to this property. It's been my perception since day one that the town's access to the street, to its water, sewer, electric easements in this area has never been in serious jeopardy. So that what we were trying to preserve from the town's perspective, access to our utilities, street access for the public, and access to the social trail would all be preserved under this. Complicating issues really arise from the surrounding property owners. Do they still have access to their particular properties? Which raises a question to me, which is the same question I raised when the proposed quitclaim deed was first proposed. How much in how many thousands of dollars of taxpayer money should the town of Lyons spend to basically try to preserve access rights to private properties? That's a tough question when you're sitting here to be sure. If the town preserves street access, social trail access, access to utility lines, how much in taxpayer money should we spend litigating about access to private property rights? I don't buy the argument that former Mayor Rogan made that we're setting some type of bad precedent here. But I think the lesson to be learned from this whole experience is the town should not accept quitclaim deeds to private property to make it public property unless there's a valuable interest of the town to be preserved, unless it's not going to cost taxpayers thousands of dollars to do that. That's the precedent to set here. Be careful about gifts of private property. The town owned no interest in this property prior to February of last year. It wasn't public property. We had a right of way across it. We had access to our easements. Public had access to the social trail, but the town didn't. This wasn't public property until our question is, how do we get out of this mess? I see the possibility of a settlement that can preserve the interest of all parties. The town's interest I've just mentioned. If the Simmons were willing to grant access in a recorded easement to the PERS for the access in their property, I think that resolves a big part of our legal issues. If we look at the southern boundary of that property and move it northward, I believe that access to the Bolette property, which is the next private property down, would also be unquestionably there. I've walked that area. I've seen the tire tracks. I believe you have the southern border of that property with an extended fence line from where the center fence runs east-west. Clearly there is access to the Bolette property there. It exists now. It's been used many times. So I think there is the possibility of a settlement that would benefit all parties and avoid costly, risky litigation for all parties, including town taxpayers. I don't think we're there tonight. The purposes of tonight will support this motion to deny the settlement. But I believe that there is the prospect here for reasonable people to agree on a solution that will accommodate all parties.
Can I make one comment real quickly?
Sure.
Yeah, and it's only that I think, as you acknowledge, the town did have a public right-of-way interest, which is a form of public property.
Correct.
Certainly it wasn't a town park, but it was town right-of-way.
Yes, you're exactly. The town had an interest in that property in the form of a right of way, that is very, very hard for anyone to extinguish. So we had an interest, we didn't have an ownership interest, to clarify,
A different kind of ownership interest, I would say. Yeah.
not fee ownership, was not our plan.
Yeah.
I agree in substance with what trustee Schwartz and Mayor Browning have said. I think I'll just restate some of this with a couple of details that occur to me and maybe in my own language. I think trustee Schwartz said this is not ready. I would say it's not ready because I don't think we have a meeting of the minds. I don't think people agree on what would be in this settlement. So as much as people have tried to document it and have tried to lay it out on the boards and on paper, I think there is still some question about whether everyone understood what the boundaries of this potentially ceded property were. So I don't think we're ready tonight because I don't think we actually have a common understanding of where we were headed. I agree with Mayor Browning when he says that notwithstanding this lack of agreement, there is the potential for agreement. I think the town was always interested in preserving people's access to this area. And ideally, that would be everyone's access, but as a fallback position, at least some limited access, maybe for some neighbors who would need to be assured in a formal way that they had access to this property. And if it is not about the value of the property, if it is not about the potential development opportunity, then having some shared access should not be a major problem, I think. And maybe by moving the southern border up a little bit, we can satisfy another neighbor. By just clarifying what we are all agreeing to, I think there is a chance to do that without anyone's interest being seriously injured. So, believing that we don't have a deal tonight, we can get to a deal if we maintain some open-mindedness about this and some focus on access to the parts of the property for the purposes that are most important. I think we should accept this resolution, accept this motion, pass this motion to reject the ordinance for this evening, and then continue to pursue what I think is a potentially very constructive path toward agreement.
Other comment?
Yeah,
Mr. Jacobs.
I just have philosophical concerns about this, and I do think it does set a precedent, and I think we always have to think about angering a large number of residents and what actions they might take and what the repercussions might be of the decisions we make here. And there's a lot of loud and clear feedback that we're getting. So I feel like I have to say that I think that Holly Rogan made a good point about the potential, whether it's an actual legal precedent or it is a precedent for what people will expect and try to do. I think you might be creating a big problem. But tonight's question is to quit granted and have already made that motion.
Sorry, just in agreement.
I just want to name that, it's very interesting to walk into something like this that has already been started, by people who are no longer sitting up here. I mean, some are, and some of us are just now walking into this, and it's a big issue at hand, and I'm sensitive to, the public concerns, and I'm sensitive to the private owner concerns as well. I'm at this time personally not convinced that ownership transfer is the way to solve some of the problems that the descendants have outlined for them, and I'm always looking for creative solutions and ways to collaborate that bring together, preserve neighborhood interest and public ownership and shared stewardship. And so I feel like this is a good way to see how we can all move forward in a clear direction in time. And I hope that mediation can maybe occur with some people. I mean, not from us, but like amongst the neighborhood. I mean, you're all
so close to each other, like physically, so it would be cool to see what can happen amongst these parties at hand. And seeing where the town is appropriate to step in and where this is, again, another interpersonal issue.
Any further comments? Not, we have a motion pending to deny ordinance 1219. A yes vote on this will result in the denial of that ordinance. Call for the vote.
That motion passes unanimously.
The remaining item on this is a resolution approving the settlement agreement. It seems to me that that resolution is needed by the vote that was just taken. Anybody disagree? Do we need to take a formal vote on that, Brandon?
You need to go vote for the record.
Okay. Then, in the interest of time, I will move that we reject resolution 2026-27 as moved. Second. Any discussion? Call for the vote.
That motion passes unanimously.
In view of the lateness of the hour, we'll suggest that we defer on discussion direction items. Brandon, do we need to do a date certain?
I have one that
I'm
is,
sorry.
number one is time sensitive, the others are not.
Okay,
Also.
you're right. Okay. First item is
Mayor,
a fast track grant.
I was just gonna say also, if we want to skip trustee reports, you can all email me your reports and I will incorporate them into the minutes and then you can approve them at the next meeting.
That has been done before. That's what exactly what I was gonna suggest. Figure this out. So item one under general business, staff.
Yeah, so we brought the kind of requests to, sorry, I'm gonna back up, it's late. As you all recall, we were eligible for a $45,000 grant from Proposition 123 Fast Track Compliance. The board discussed a variety of options to take back to DOLA for consideration of those. They recommend that the work for ADUs come under the ADU Supportive Jurisdiction Grant, which opens up on August 3rd. There is a 25% local match, so I think staff might work through kind of the budget process for the rollovers to see if there's anything left in there, but if whatever it is, for ADU work. And then we would suggest the grant work to support the housing action plan, acknowledging that $45,000 wouldn't get the entire consultant work done, but nor do we think that's a good idea. I think staff would like to retain kind of the policy lead and plan kind of alignment with the board priorities and previous work, and then just use a consultant for data collection, development of a plan document itself, and assistance with public engagement. Due to the grant timeline, it's unlikely that we would probably have access to those funds until closer to 2027, which aligns when we probably need to kick that off. So that's staff's recommendation.
Questions, staff on this item?
Just so I'm clear on this will now be, by my count, we do this housing action plan, it will be the sixth housing related plan or needs assessment that we have done in about the last 7 years, I think. And we started out with the Lions primary planning area. We had the comprehensive plan, the Thrive comprehensive plan, the Lions future housing, the Lions housing future plan, Dr. Cog regional needs assessment, the community housing needs and growth survey that we did 2 years ago, which is more of a survey, but it had actions coming out of that, and I really was behind. I'm getting confused, and I don't know how many of these are gonna start working counter against each other. So that's just my comment.
My comment, gone through most of those two, is that I am in favor of internally town staff taking charge and reporting to the town board, of course, taking charge of whatever additional housing related study needs to be done. Our experience with consultants has been very poor in this area. The Dr. Cobb assessment is, I call them phony numbers. They're incorrect numbers. The Housing Futures Plan done by an outside Dole funded consultant. We had to spend a lot of board time at the urging of citizens correcting that document that had major errors and omissions. So I applaud the effort to at least direct any future thing that must be done internally rather than basically letting the consultants take the lead and using consultants for gathering data as opposed to proposing ideas and drafting a report. I applaud that. I will note for the record that whether we need to do a housing action plan will depend on the state of, will depend on the state basically and where things stand with whoever the next governor is late next year. We've seen what Governor Polis says that he would like to do if you don't do a housing action plan. I don't know who the next governor is going to be or what the next governor may say about the consequences of not doing a housing action plan. In my mind, that decision of whether to do a housing action plan, which involves how much is it going to cost, what are the potential benefits, and what are the risks of not doing one, needs to be determined after we see what the next administration is and where things stand. But this would give us at least some state grant money if we end up, if the decision is ultimately to do one, to gather data, and so I'm in favor of applying for this grant. Or accepting this grant, I should say.
So yeah, that would be the answer to Greg's question, is that this is a mandate and they do have different colored rocks that they want us to bring.
Yes.
Cause that's the way it works.
Yes, yes.
So I'm with Mark. Money, good. TBD on the content. And definitely be skeptical of consultants.
We will use them to support staff, not lead project. That would be my intention.
I'm in favor of that. I do think it's a different, more forward-thinking, concrete, much more localized feasibility almost report that's different than the previously stated ones. So thumbs up for me.
Seems to have a majority in favor of accepting that.
Right.
Now, the other three items, do we want to deal with them at all tonight, or should we put them to a later agenda?
I suggest we continue that.
Later agenda, and since these are discussion direction, we can discuss what among the agenda setting process, we can discuss what dates they belong on later.
Yeah, well, Hunter Ritchie will not be here at the next meeting, and you want her involved with wildfire mitigation. We might want to wait on that one just a little bit, but I think we can handle the others.
Yeah, you will need to continue them to a date certain though, so we'll have to specify which dates.
Yeah.
That's true, even on discussion direction items, okay.
They were
So,
noticed agenda items, so.
Okay, I would suggest we continue item number 2. Stand deck area wide plan presentation, the preference of the board be, I don't believe that will take very long. We have a special meeting, which we will load up the special meeting agenda,
No, because it's supposed to be one out by
All right.
lunch hour.
July 6th,
July 6th, that was a fairly light agenda.
okay.
Great.
So you just tweeted.
What
Consensus
meeting
of the board
would
with
that
that
for
July
July?
6th. And then wildfire mitigation strategies discussion, I agree that needs to be done when Planner Ritchie can.
July 20th would be my first meeting back.
Okay, July 20th, okay, and everybody else on that?
Is there no reason that we have to move this forward before July 1st?
No, the
No.
code is already in place, so this is just
These
policy
were those
direction.
extra strategies.
And then the fourth one is procedures for citizen agenda request.
July 6th.
Which is lighter, the 6th or the 20th, do you think? Same.
It's early for the 20th yet, so kind of hard to know what else
Yeah.
might come up, but you and I can,
Let's for now suggest that on the 6th, and if something, too many other things come on the 6th, we can pick that. I mean,
Okay.
it's something that we do keep getting citizen agenda requests, and there's still
Yeah.
no established procedure or process for exactly how they're handled, so it is something that's important at some point, so. I'm in this as well. Not yet, just one from something, exactly this list. And then. Trustee reports as Clerk Vasquez has suggested, and we've been in this situation before. We simply ask any trustees to just submit those by writing and they could put in front of clerk and it just.
But we have one thing to add to that one.
All right,
Everyone, please check your email more frequently. Tony Blind's email.
Yeah. I still haven't heard from everyone on the retreat, so I can't even get it scheduled yet. I need to tell the person what we want to cover. And right now, all of your priorities are very different, so. I'd like to hear from the rest of
if
you.
everyone make sure we respond to that request prior to the next meeting, that would be very helpful.
Do we have a date set for the 20, or a time set?
No.
For the 29th?
Oh, for the 29th, it was new.
What's fun?
Okay, noon, okay.
And it can be well, we were talking about it could be virtual, but it's growing. It's okay to be virtual. 1 hour.
Okay, I knew we talked about that, I wasn't sure we said that, okay.
Summary of action items.
Go right ahead.
I'm sorry, Trustee, you say something?
I just request that you want to be bumped that request for the retreat. Just like.
Resend.
Yeah, it's
That
like
would be
definitely like
Sure.
buried.
You
I
submit.
know, I just knowing that mine was like this, so it was just for like something to
I
go.
just responded today.
I would add to what Mayor Pro Tem Wingard said, about checking your email. I've had real issues lately with substantive emails going into my other inbox, which other email systems could be called the junk email box. You gotta check that too, because things keep showing up in there that are substantive matters from, you can check both boxes, unfortunately. Summary of action items.
All right, number one, I have where to send the detailed Stantec report to the board. Trustee McCreary requested that. Board number two, board consensus is that Kim Mitchell will be an ex officio for LCD. Number three, code enforcement report needs more stats and maybe updated tracking of projects being done. Number four, ordinance 1222 passed on first reading, and board or staffer to bring red lines to the second reading. Ordinance 1220 passed on second reading. Ordinance 1221 passed on first reading with amendments. Ordinance 1219 failed. Resolution 2026-27 failed. And discussion direction on the workshop, the Stantec area-wide plan was moved to a date certain of July 6th. Discussion direction on the wildfire mitigation workshop was moved to a date certain of July 20th. Discussion direction on procedures for citizen agenda requests was moved to a date certain of July 6th. And staff is to resend the retreat email to the board.
Only have one item, and that was approval to submit the power ahead grants. That's it.
I would gladly entertain a motion to adjourn. Look.
We're 4 minutes away from it.
No. So through.
Yes, Monday to
Motion passes unanimously.
Yeah, have a good night, everyone.
Good night.
Thanks, Brandon.